New York was once the unrivaled capital of capital. Wall Street, Silicon Alley, global headquarters abound. Today, the defining image is somewhat different. Rather, it is that of corporate jets lifting off from Teterboro, bound for places like Florida or Texas, carrying with them entire companies and their taxable income. Today, we will again revisit the mass exodus of companies from the Empire State to greener pastures and the specific legal procedures and protocols necessary to effectuate that move. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the great states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in tax, in addition to 11 professional licenses and certifications spanning accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. New York State generally and New York City specifically continue to face severe structural deficits driven by persistent overspending, and these trends are likely to be exacerbated by recent high profile election results. You know the one I'm talking about, I don't even need to mention it here. Rather than pursue fiscal restraint, policymakers and politicians have instead chosen to intensify taxation on high earners and businesses, accelerating an exodus that is already well underway. Major financial, legal, and technology firms have relocated their domiciles to Florida or Texas, and many more are in the process of doing so. The combined state and city marginal income tax rate already exceeds 15% for the highest earners. Proposals now under serious consideration would push the city's top rate still higher and extend existing surcharges on high net worth individuals for years to come. Corporate tax increases are also being actively debated. These measures, if applied to income earned in prior periods or structured in creative ways that capture wealth accumulated while a company, and in some cases, the company's owners, were domiciled in New York, these function as a de facto exit tax or exit penalty on enterprises that choose to leave, similar to what we are now seeing in California. From the perspective of a CEO or a board member, the calculus is straightforward. A company that spent decades building its operations in the Empire State already paid some of the nation's highest wages, corporate franchise taxes, commercial rent taxes, and payroll taxes. It has already contributed billions to the state's revenue base. Yet, the moment it wants to relocate its legal headquarters and senior personnel to another more business friendly state, things can go south. This is not taxation, it is retrospective punishment that is being considered for having already succeeded in New York in the first place. The consequences are measurable and severe. The top 1% of New York taxpayers already account for more than 40% of state income tax revenue. When a single business, be it a financial services firm or a mom and pop startup, move to Florida or Texas, the annual revenue loss to New York can be quite substantial, which is further compounded by the departure of highly educated, high earning employees who will soon follow. History demonstrates that such revenue shortfalls are rarely, if ever, offset by the intended tax and regulatory changes. Instead, the remaining tax base further depletes, requiring yet higher rates in a self reinforcing spiral. The constitutional questions are equally grave and profound. While retroactive taxation is not categorically prohibited, the Supreme Court of the United States has repeatedly held that it must not be, quote, harsh and oppressive or deprive citizens of fair notice and reliance on existing law. Measures that effectively confiscate a portion of wealth accumulated under one tax regime in the past simply because a company or individual later chooses to relocate to Florida or Texas under the new tax regime invite serious due process and takings challenges that remain unresolved at the federal level at this moment. Enterprises, both large and small, must be able to plan for relocations and really their entire operational strategy based on the tax and regulatory rules in effect at the time they make their decisions, not rules that may be rewritten afterward to recapture revenue from a jurisdiction they have lawfully exited. I've helped countless companies, large and small, move out of New York into places like Florida and Texas. In fact, my law firm now performs more of these so called redomestications than any other law firm in the state. Until New York recognizes that capital cannot be taxed into submission, the dissipation to the Sunshine State and the Lone Star State will accelerate, leaving behind a state that can no longer afford the ambitions it once financed. If you need help moving your company out of New York, please use the link in the description for more information, which includes the ability to schedule time to speak with me about this complex process. Or better yet, you can complete the process on my website in under 5 minutes. Yes, really. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on this topic, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.